This is the Employment Tribunal's judgment in the case of Mr. J. Fisk versus J. Fisk is claimant versus Royal Mail Group Limited, the respondent, which was heard at Bury St Edmunds on the 23rd, 4th and 5th of August, with a discussion in Chambers on the 26th of August, before Employment Judge Brian Mitchell and Sidesman and women, Mr. C. Walsh and Mrs. L.R. Simpson, the claimant represented in person, and the respondent by Miss S. Faru, counsel, and the case number is 1501214/2009. Okay, and it says the judgment. The claimant was unfairly constructively dismissed. The claimant was a disabled person at the relevant time by virtue of his dyslexia and dyspraxia. His claim of disability discrimination is dismissed upon withdrawal. Remedy will be considered on the 14th of October 2010 at 10 a.m. Reasons. The claimant maintained that he was discriminated against on the grounds of his disability, which he contended was that of asthma and dyslexia/dyspraxia. The claim was presented on the 7th of April 2009. There was a case management discussion on the 10th of July 2009, but no appropriate list of issues was set out, and it was anticipated in the case management order that the claimant would be asked for further and better particulars of the claim, to which he would respond. No request for further and better particulars was made. The parties were not easily able at the commencement of the hearing to identify the issues which the tribunal would need to resolve. The tribunal therefore decided to commence by determining the clear and discrete issue of whether the claimant was disabled by reason of either or both of asthma and dyslexia/dyspraxia. Two, upon the tribunal determining that the claimant's asthma was not a qualifying condition under the Disability Discrimination Act, but the dyslexia and dyspraxia was, the parties, at the invitation of the tribunal, together agreed the list of issues in the case. The issues raised by the claimant in relation to the disability of dyslexia/dyspraxia were set out to be a failure to allow use of a dictaphone on the 4th of April 2008, an expectation on 28th of March 2008 that the claimant would be aware of the mandatory attendance of work time listening and learning sessions, and an allegation that the claimant suffered stress as a result of the respondents failing to take action in response to the claimant's concerns. The respondents contend, firstly, that the claims are presented out of time, secondly, that no valid grievance under the Employment Act 2002 was raised in relation to them. Thirdly, that the claim forms do not support those claims and leave to amend would be required and should not be granted, and that the claims have no reasonable prospect of success. Number 3, as the respondents indicated, that if the first two issues were allowed to proceed, they would need to seek an adjournment to call an additional witness, and as the issues concerning grievances raised technical matters on which the claimant might need some advice, the tribunal decided that it would proceed with the claim of unfair constructive dismissal, and at a later date would determine whether the disability discrimination claim should be struck out. The same tribunal will consider that preliminary point at a date to be fixed. Right. On disability, number 4. The claimant maintained that he had a disability of asthma, and the tribunal was assisted by a jointly instructed report for the purposes of this hearing by Professor Douglas, whereby he notes that there was a diagnosis of asthma from 1991. Quote, "But I get the impression that this is a very mild form of asthma and seldom troublesome. He only occasionally now needs to use Ventolin, and apart from a bad week with early morning waking cough and unable to get his breath at the time of the problem with the air conditioning, he reports that he has only had 3 similar experiences in all his living memory." Unquote. Number 5. The claimant is a regular smoker of cigarettes in the region of 20 per day, and when he was examined prior to starting work as part of the pre-employment health assessment by an occupational health advisor instructed by the respondent, the report shows, quote, "From my assessment, I consider he should be fit to perform a full range of duties for a delivery postman. He receives very occasional and minimal medication at present, and should he experience any downturn in his symptoms, additional medication should soon bring symptoms under control. At this stage, he does not appear to suffer substantive impairment on a regular basis, and therefore the Disability Discrimination Act is not likely to apply." Unquote. Number 6. When Professor Douglas considered the competencies which are set out in the Disability Discrimination Act as requiring examination, he considered that there was no difficulty with ability to lift, carry, or otherwise move everyday objects, with the exception of handling heavy boxes, and that none of the other functions were affected at all, insofar as he had difficulties with manual dexterity and physical coordination. The professor concluded that they were not due to his asthma. 7. The claimant accepts that, with the exception of the occasions when he was asked to work in the registered locker, a confined space, by the respondent, he was not unduly affected by asthma, and over the period of working for the respondent, he had very little absence on that ground. Number 8. The tribunal reminds itself that for an impairment to amount to a disability, it must be a physical or mental impairment having a substantial long-term effect on his normal day-to-day activities in relation to certain specified functions. There is no doubt that the asthma is a long-term impairment. The question arises as to whether there is a substantial impact on his mobility, manual dexterity, physical coordination, or ability to lift and carry, or otherwise move everyday objects. The joint report clearly suggests that there is minimal adverse impact. We do, however, have to have regard to Schedule 1, Paragraph 6(1) of the Act, which requires us to disregard treatment in considering the adverse effect. The treatment the claimant was receiving was designed to prevent asthma having a substantial effect, and an additional medication should there be an asthmatic attack. What is not clear is the frequency or otherwise of the claimant taking the medication when prescribed. The professor's report makes no reference to that aspect, save to say he only occasionally now needs to use Ventolin. The ATOS reports suggesting that he receives very occasional and minimal medication. It is for the claimant to prove the disability, and in the absence of any evidence of substantial adverse effects, if the medication was not taken, the tribunal must rely upon the medical report in concluding that there is no substantial adverse effect on the claimant's day-to-day activities by reason of his asthma. That was number 9. Number 10, turning next to the dyslexia and dyspraxia. It is clear from the claimant's background that he attended special educational establishments during his schooling and on some occasions had home tuition. But oddly, there was no diagnosis until the claimant, whilst working for the respondents, decided to undertake a degree in history. He found difficulty in handling the material that was needed for his degree, and it was suggested that he should be examined by an educational psychologist. Mr. Francis, in November 2007, identified that he had, and I quote, a superior academic potential comfortably within the top 5% of the population, unquote. But that the dyspraxia caused handwriting difficulties, that his development of spelling skills had been affected, and his sight reading skill impeded. It was also concluded that his weak auditory working memory skills and weak visual working memory skills were connected to dyspraxia and dyslexia, and that those caused him difficulties in following lectures and taking notes. He opined that students with dyspraxia routinely experience difficulties with the organisation, structure and planning of written work, and it was suggested that he would need substantial extra time for any examination, that he may need to record lectures rather than be expected to make notes, and that he may need assistance with organising research. For the purposes of the for the purposes of the tribunal, we have the report of Dr. Banks, a vocational and employment consultant, who reported on the 16th of November 2009. He noted that the claimant does not read magazines or newspapers, that he has difficulty taking notes and uses a dictaphone, that he failed a manual sorting test at the post office, and that he accepted Mr. Francis's report and the diagnosis of dyslexia and dyspraxia. He therefore concluded that the conditions were lifelong conditions and therefore satisfied the long-term requirement. In relation to normal day-to-day activities, he concluded that, quote, the situation is not quite so clear, unquote. He did not consider that there was a substantial impairment in his communicating in writing and speaking clearly, and the ability to concentrate, learn, and understand. He went on to say, quote, it is not to devalue the importance of his difficulties at work as he describes them, unquote. Number 12. We have reminded ourselves of the case of Patterson versus Metropolitan Police 2007, IRLR 765, which recognised in the context of that case that, quote, carrying out an assessment or examination is properly to be described as a normal day-to-day activity. Moreover, reading and comprehension of themselves normal day-to-day activities, unquote. Further, quote, the only proper approach to establishing whether the disadvantage was substantial is to compare the effect of the disability on the individual. This involves considering how he in fact carries out the activity compared with how he would do it if not suffering from the impairment. If that difference is more than the kind of difference one might expect taking a cross-section of the population, then the effects are substantial, unquote. Number 13. In our judgment, the claimant's difficulties in handling or organising material, his need to have extra time for examinations or tests, his difficulty with reading at the initial learning stage were disadvantages which took him well outside the range of normal cross-section of the public. Based primarily, therefore, on the report of Mr. Francis, we differ from the conclusion drawn by Mr. Banks, who himself expressed the view the question was not clear, and find that the dyslexia and dyspraxia did have a substantial adverse effect on the claimant's communication, ability to concentrate, learn and understand. Accordingly, we consider that the claimant was at the relevant time a disabled person by reason of dyslexia and dyspraxia. Unfair dismissal. Number 14. The claimant commenced work with Royal Mail as a full-time delivery postman on the 7th of August 2006. Excuse me. He had a good working relationship with his line manager, Mr. Tony Salmon. But when Mr. Salmon was away from work, Mr. McGarry took over his duties. In November 2006, the claimant reduced his hours from full-time to 15 hours per week in order to attend university for a degree in history. Number 15. One of the duties which the claimant undertook was to work in an area which was called the registered locker, dealing with registered post. The atmosphere contributed to the claimant having a short period of absence as a result of his asthma, and upon his return to work, at an interview, he was relieved from duties in the registered locker. Number 16. In January, Mr. McGarry asked the claimant to work in the registered locker, and the claimant refused. This incident became the subject of a complaint by the claimant, as did Mr. McGarry's request that he work on Road 5 with effect from 25th of March. The claimant objected to this as he considered that one of the operatives working on that duty did not pull her weight. On his own evidence, the claimant accepts that he expressed the view that she was effing lazy. And Mr. McGarry's recollection was that he termed her a fat, lazy cow. The move to this different duty formed the subject of a complaint which the claimant lodged in April 2008. Number 17. The claimant did not attend a work time listening and learning session on the 27th of March 2008, but was again asked to sign an attendance sheet by Mr. McGarry on the following day, which led to an altercation with Mr. McGarry. The claimant complained of this to Mr. Mottershaw and raised the incident as part of his April grievance. On the 31st of March, the claimant returned to the primary sorting duty for which he had no objection. On the 22nd of March 2008, the claimant wrote to the mail centre manager. He complained that the individual whom he described as lazy was not performing her duty was preferring to stand around talking or using a mobile phone, and that it appeared that no one was monitoring her performance. He complained that Mr. McGarry had put him on a duty with this individual, which he described as inflammatory situation which may jeopardize my position with this company, and a situation which will certainly involve me doing more work to compensate for the idleness of another. He went on to say, I see this move as vindictive because I had the audacity to complain, a form of punishment designed to silence me, and as such it constitutes harassment. He reminded Mr. Turvey that prior to his work at Ipswich office, he had 11 years previously with the Royal Mail working at Colchester. He received no response from Mr. Turvey in relation to that letter until 14 April. Number 18. On 3 April, the claimant attended a work time listening and learning session, which was being led by Mr. McGarry. He was asked to leave the room by Mr. McGarry when Mr. McGarry noticed that he appeared to be reading a book during the session. Mr. Mottershaw learned about the claimant having been ejected from the work time learning session, and as he had mentioned the possibility of a reconciliation meeting when approached on 28th March by the claimant reminded him, and he arranged a reconciliation meeting for the following evening, the 4th of April. The claimant attended with Mrs. Pam Porter, a work colleague, as a witness. That meeting appears to have been entirely unsuccessful, as although the claimant was prepared to offer an apology for his behaviour at the work time learning session, Mr. McGarry was not prepared to accept it and wished for a public apology. The claimant terminated the meeting and contacted a Mr. Oliver, the legal advisor, on the bullying helpline provided by the respondent. Number 19. Pursuant to that conversation, the claimant submitted on the following day a grievance on the form H1 headed Bullying and Harassment Complaint Form. In that form, the claimant identified his complaint as being against Mr. McGarry in the Ipswich Mail Centre, and he requested that his manager should not handle the complaint. He attached to that form both the letter he had written to Mr. Turvey on the 22nd of March and a further 7 pages covering his complaints in relation to him being ordered to work on Secondary Road 5 after he had given a reason why he should not do so, and the effort by Mr. McGarry to require him to sign an attendance sheet for a learning session which he had not attended, where Mr. McGarry was said to raise his voice at me in an intimidating manner and threaten to discipline me. He also referred to his attendance at the work time learning session at which Mr. McGarry had told him to leave the room, and to the reconciliation meeting of the 4th of April when he said that Mr. McGarry had proposed to commence the misconduct procedure unless the claimant went to the following session and made a public apology before the whole room. Number 20. The claimant then went off with medically certified work-related stress. Mr. Mottershaw wrote to the claimant on the 18th of April thanking him for written details of your complaint that Mr. J. McGarry has behaved in a bullying, harassment manner and has used threatening behaviour towards you. He said that he was proposing to proceed with the claim under the grievance procedure, and that as the complaint was against the work area manager, it would be dealt with by the second line manager, and suggesting a meeting to discuss it on 22nd of April. Number 21. The claimant responded to the effect that he did not wish his managers to investigate the matter, as it was a complaint against another Ipswich manager. He also made the point that he would not attend a meeting at which Mr. McGarry was present, and suggested that the matter should be investigated by ER Operations. The ER is Employee Relations, Mr. Dignan. There appeared then to have been a discussion between Mr. Mottershaw, Mr. Turvey, and the Human Resources partner in Ipswich, which led to Mr. Dignan writing to the claimant on the 1st of May, saying that the grievance would be dealt with by Mr. Lee Matthews, a Woodbridge cluster manager. Number 22. But by 23rd of May, the claimant was informed that the complaint would be dealt with by Mr. Gareth Keeble, another manager at the Ipswich Mail Centre, with no cogent explanation as to why Mr. Matthews, who had been directed to deal with it on 1st of May, was no longer handling it. No explanation from the Employment Relations Department was put forward. Mr. Keeble asked the claimant to attend a meeting on the 1st of June. On the 4th of June, the claimant complained at the meeting that the procedures had not been met in relation to his bullying complaint, and that the deadlines and stages for each procedure had not been followed. Mr. Keeble apologised for the delay, but said this has not been seen as a bullying and harassment case, and has been given back to be dealt with under the formal grievance procedure. His note as to the purpose of the meeting was that it was to find a way for the claimant to get back to work, to which the claimant responded that he was happy to get back to work, but did not wish to be bullied and harassed in the workplace. Number 23. On the 11th of June, Mr. Keeble wrote to say that he would need to review the case in full and that there would be a short delay in providing a decision. The decision was communicated on the 8th of July. Mr. McGarry's findings were that the decision to move the claimant, that should say Mr. Keeble's findings, were that the decision to move the claimant to Secondary Road 5 was a correct procedure, that the request for the claimant to sign the attendance form was an inappropriate request, that the claimant should not have read his book in the working time meeting, and that Mr. McGarry should not have demanded a public apology and should have accepted the claimant's apology. Number 24. The letter of finding thanked the claimant for attending to discuss your complaint that Mr. McGarry has behaved in a bullying and harassment manner and has used threatening behaviour towards you. No finding was arrived at in relation to that complaint. Instead, Mr. Keeble sought that they should meet to effect a reconciliation and that the restorative conferencing might facilitate that. Number 25. By letter of 11 July, the claimant rejected the reconciliation meeting proposed for 16 July, as Mr. Keeble had intimated at a meeting on 9 July that Mr. McGarry had not been happy with the conclusions reached. As it appears that Mr. McGarry does not wish to accept your judgment in this matter, it seems unlikely to be productive. He did point out, however, that there was no finding in relation to Mr. McGarry raising his voice, coercing him in a bullying manner, or threatening to discipline him, and therefore declined the proposal for a reconciliation meeting. Number 26. Mr. Keeble responded on the 16th of July, asking the claimant to consider whether the claimant would wish to explore a mediation between yourself and Jim McGarry. This will be facilitated by a fully trained mediator from Atos Healthcare. Number 27. On the 23rd of July, the claimant pointed out that he had agreed to undertake restorative conferencing provided that it does not negate my position or the grievance procedure. He again mentioned that Mr. Keeble had not dealt with the allegation of bullying and that his findings were therefore unsatisfactory, and enclosed a Stage 3 appeal, and again mentioned the delays in responding to his grievance. Number 28. In his grievance appeal form, he sought that the matter be investigated in an unbiased manner and suggested that certain witnesses should be interviewed who may have witnessed the altercation on 28th of March. Number 29. On 29 October, Mr. O'Shea wrote to the claimant saying, "Following your non-acceptance of the restorative counselling that we agreed for you and Mr. McGarry, I have forwarded your Stage 3 of the grievance procedure to the Gateway team at Rugby for allocation." He went on to say that the claimant could return to the late shift duty, noting that the claimant did not work together on that shift, and gave an assurance that the claimant would not have any dealings with Mr. McGarry, and asserted that he was reminding Mr. McGarry that each should treat the other with respect if they encounter each other. Number 30. Again, the Employee Relations Department became involved. Acknowledging receipt of the Stage 3 grievance complaint form on the 5th of November 2008. And the claimant was informed that he would be contacted as soon as an investigative manager had been appointed. Mr. Marsh, a collections and distribution manager of the Ipswich Distribution Centre, was appointed on 20th of November. On the 21st of November, the claimant objected to another manager within the Ipswich Mail Centre being appointed and requesting that a manager not based in Ipswich should be appointed. That request was refused on the 22nd of December. Number 31. On the 20th of January 2009, the investigating officer, Mr. Marsh, who had been appointed on the 20th of November 2008, claimed that the claimant called the claimant and asked him to attend a meeting on the following day regarding his Stage 3 grievance appeal. The claimant clandestinely taped that meeting, which lasted for 2 hours. During that meeting, Mr. Marsh appeared to express some concern that the matter had not been dealt with from the outset under the bullying and harassment process. The meeting took 2 hours. Mr. Marsh considered that it was an informal meeting to assess the complaint. Mr. Fisk, who had attended with a witness, thought it was the Stage 3 appeal. Number 32. On the 11th of February 2009, the claimant, who had been expressly informed that he would not work in proximity to Mr. McGarry by Mr. O'Shea, found that Mr. McGarry was working on the sorting frame next to him. He felt that this had been deliberately manufactured by Mr. McGarry to provoke him, and when he asked to be moved, Anne Mason, the relevant manager, initially refused. But when the claimant refused to work next to Mr. McGarry, he was moved, and his evidence was that Mr. O'Shea witnessed the event. As he put in his fresh bullying and harassment complaint submitted on the 12th of February, quote, "How much harassment, bullying and intimidation am I expected to endure in this company before somebody will take action against this man? So far this issue has cost me over 4.5 months sick absence from work, caused me a lot of stress, and has had a severely adverse effect on my personal and academic life." Unquote. On the following day, number 33, on the following day, he was sent a letter by Mr. Marsh inviting him to the Stage 3 grievance meeting. The claimant replied on the 15th of February explaining that he had already had the meeting and that Mr. Marsh had already had the full file of papers for 8 or 9 weeks. He then expressed his view that the grievance procedure had been terminated by the respondent's default and that he did not intend to attend the meeting. Mr. Marsh responded that the initial meeting had been for him to gain an overview of your complaint before deciding what course of action to then progress, and suggested a further meeting on the 25th of February. Number 34. On the 19th of February, the claimant was taking legal advice when he was contacted by Mr. Dean Baker of the ER department, who the claimant interpreted as saying to him that he did not think Mr. McGarry's behaviour constituted bullying and harassment. On the following day, he found out that Tony Salmon, one of his managers, whom he had expressly requested in his bullying and harassment form of the 5th of April 2008, should not conduct the investigation, had been appointed to investigate the bullying and harassment complaint. Number 35. On the following day, the claimant resigned by letter addressed to Dean Baker at the ER department saying, and I quote, "Further to our telephone conversation at 2 p.m. on Thursday, by which you inform me that you do not consider the latest incident in my harassment complaint to constitute any form of bullying and harassment, and further to the unnecessary, protracted," misspelt there as protected, "and poorly handled procedure which Royal Mail has used to deal with my complaint since 2008, and its failure to deal with my appeal, and in view of the treatment of myself by Mr. McGarry, which gave me reason to complain in the first instance, and because of the unfair and reasonable stress, anxiety, and sickness which I have endured as a result of this whole situation, together with the adverse impact, which it has had on my personal, academic, and working life, I feel that I have not been, as an employee of the company, protected by Royal Mail under its legal duty of care to its employees, nor have I had a reasonable and timely satisfaction of my complaint. Furthermore, I feel there is no insurance or prospect of this in the future, and I am thus physically, mentally, and emotionally unable to continue with my employment with this company." Unquote. Number 36. Mr. Salmon then embarked upon an investigation of the claimant's 12th of February 2009 bullying and harassment complaint, which was expressed to include all the matters complained of in the 5th of April 2008 complaint, without input from the claimant. Mr. Salmon reported on the 20th of March that bullying and harassment did not take place on the incidents of 20th of March 2008, 28th of March 2008, 3rd of April 2008, 4th of April 2008, and the 11th of February 2009. Number 37. Under the bullying and harassment procedure, it is identified that there may be an occasion where an alternative manager may be appropriate, particularly whereas there is reason to believe that the line manager is the subject of the complaint. This could mean that the complainant will need to be seen by someone from outside his or her area. Unquote. And, quote, in any case where a completion of the investigation within the 28 days target is not possible due to the complexity of the investigation, the complainant and respondent will be advised accordingly. Unquote. Relevant law, number 38. A claimant can only be unfairly dismissed where there is a dismissal. Section 95, Employment Rights Act 1996, brackets ERA, close brackets, provides that where an employee is entitled to resign as a result of the employer's conduct, such resignation is treated as a dismissal. Number 39. It has been established by the higher courts that this involves a consideration of the civil law of contract. The tribunal must ask itself whether there has been a breach of a serious implied or express term of the contract entitling the claimant to resign, whether he resigned in response to that breach, and whether he has by his conduct or delay affirmed the breach and forfeited his right to accept the repudiatory conduct of the employer. Number 40. If there is a dismissal, it is for the respondents to show a fair reason to dismiss. That has to be a potentially fair reason identified in Section 98 ERA, Employment Rights Act, or some other substantial reason. In this case, the respondents have not sought to advance a fair reason to dismiss. The case therefore turns on whether the claimant was entitled to resign. Number 41. The claimant relies upon the implied term of trust and confidence. This requires that the respondents should not act without reasonable cause in such a way as to be calculated or likely to destroy or seriously damage the relationship which should exist between employer and employee. It is established that the trust and confidence term is a fundamental term. A breach of that term entitles an employee to resign. Conclusions. Number 42. Whether right or wrong, the claimant considered that he was being bullied, harassed and threatened by Mr. McGarry. He contacted the bullying helpline and was told to complete a form, which he did. That form is a form specific to the bullying and harassment process. On that form, he requested that the matter should not be dealt with by his line managers. He appended to that form details of his complaint under the heading Formal Grievance. Number 43. The respondents expect that complaints of bullying and harassment should be concluded within 28 days. It identifies that a formal complaint is one where the individual fills out a harassment complaint form. The claimant did so. There is a different form for a grievance, which he did not complete. He complied with the respondent's formalities. The respondents defined bullying as, quote, intimidation on a regular and persistent basis, or as a one-off, which serves to undermine the competence, effectiveness, confidence, and integrity of the person on the receiving end. A bully misuses his or her power, position, or knowledge to criticize, humiliate, and destroy a subordinate colleague or their manager. End of quote. Number 44. Any reasonable manager reading the complaint would understand it to be a complaint of bullying. Mr. Keeble, when he expressed his findings, referred to it as a complaint of bullying and harassment, but made no findings as to whether it was proven or not. The claimant clearly felt that the actual complaints had not been addressed. He made that clear in his response to Mr. Keeble and processed the matter to the next stage. Although he presented his appeal on the 23rd of July 2008, he received no acknowledgement of that appeal until some 3 months later. His Stage 3 appeal, submitted on the 23rd of July, led to a discussion on the 21st of January with another Ipswich Mail Centre manager, despite his complaint that it was inappropriate, when after a 2-hour meeting he received no conclusion until he was requested almost a month later to attend a meeting to discuss his appeal. The claimant can be, number 45, the claimant can be forgiven for considering that, despite his objections to Ipswich Mail Centre managers carrying out an investigation into the bullying carried out by another manager in the same centre, should form the view that the respondents were not taking his grievance seriously. A responsible respondent, operating nationally with offices geographically spread, should have taken note of the claimant's unwillingness to have his complaint investigated by fellow managers at the claimant's centre, at the same centre. There was an attempt to have Mr. Matthews of a different office to carry out the Stage 2 grievance, but after approximately 3 weeks, the claimant was simply informed that he was not dealing with it and it was going to be dealt with by an Ipswich Mail Centre manager. Number 46. After approximately 10 months of failing to provide the claimant with a substantive response to his grievance, and at a point where the claimant submitted a fresh bullying and harassment form with one additional grievance relating to the incident in February 2009, the claimant regarded it as the last straw when he was telephoned by an individual who had received his form to point out that the individual did not consider the 11th of February incident as being bullying and harassment. The claimant's decision to resign was not altered when he learned that the bullying and harassment form which he submitted in February 2009 was to be investigated by Mr. Salmon, whom the claimant had specifically requested in the 5th of April complaint should not deal with it, was to carry out the investigation. Mr. Salmon acknowledged to the tribunal that he was great friends with Mr. McGarry at work and that they spent their break time together. Number 47. It is of note that once the claimant had resigned, it took the respondents only about 1 month to arrive at a decision as to the merits of the grievance. Number 48. The tribunal considers that the way in which the respondents handled the claimant's grievance, that he had been bullied and harassed by his manager, was dealt with such lack of urgency and attention to the claimant's wishes or their own procedures that their actions were unjustified. They were likely to, and did seriously, damage their relationship with the claimant. Accordingly, we consider this inept handling of his grievance over many months broke the implied term, and that he was entitled to resign. This was a dismissal. The respondents have not sought to show a fair reason to dismiss, and accordingly the claim of unfair dismissal succeeds. Number 49. The question of remedy will be addressed at a hearing on the 14th of October 2010, as the claimant has, subsequent to the hearing, withdrawn the disability discrimination claim by letter of 27th of August 2010. Employment Judge Hobson signed on the 6th of September 2010. Bear with me. Oh, sorry. Right, here we are. And on the 14th of October 2010, at Bury St Edmunds, the judgment on remedy was heard and given, or the remedies hearing and the judgment on remedy. Judge Brian Mitchell, Employment Judge Brian Mitchell, C. Walsh, L. Simpson, same panel. Further to the tribunal judgment of the 6th of September 2010, it is ordered that the claimant be re-engaged by the respondent at the Norwich sorting office at an operational postal grade at a pay rate of £355.48 per week on a full-time basis in accordance with the terms of the contract signed by the claimant on the 5th of August 2006. In addition to the claimant's pension rights and share entitlements, are to be restored. Compensation for lost earnings in the sum of £13,346.07 is to be paid. The recoupment regulations apply to that sum in respect of the period the 22nd of February 2009 to the 14th of October 2010. No award of costs is made. And it's signed 15th of October 2010. I'll bring you the rest in another instalment. Be interesting to see whether All Mail would like to make any comment before I do so.